I haven't talked to you yet.
Yeah.
What is this yellow highlight mean in your courtroom?
That's
No, it's in custody.
Oh. It's Wanji.
For Mr. Araujo, she just talked to him. He's gonna be left out for exam. Actually took that file.
He's in custody. Leon Smith.
okay.
And so.
Is Mr. Chaz Smith here?
2 cases. He's not in Zoom and he's not in hallway.
No one's on yours?
Okay.
And they cut him loose.
On the record, in the matter of the people of the state of Michigan versus Chaz Nicholas Smith, file number 24-01087. Counsel appearance.
Abigail Wilson for people. Assistant Public Defender Sarah Donnelly on behalf of the defendant Chad Smith was not present. It's my understanding that he was taken into custody in the county jail yesterday.
In Ingham County?
Yes.
Thank you.
Yeah, he wasn't out there with the jail yesterday.
So what?
He said, yeah, he wasn't in here only with the jail yesterday. He's in custody now.
Okay, today was the date set for a probable cause conference before Judge Tony Flores. Matter is scheduled for preliminary examination, May 16th, 8:30 in the morning. Did you speak to him before he was taken into custody?
No, I wasn't able to get a hold of him this week, Your Honor. I would just ask that this be left for the preliminary exam next week.
Okay, I'll note that on the file. Additional matters on the record for that file.
Not for the people. None for defense.
Thank you, you're all set. Have you seen Ms. Robertson on Thompson?
Plus a second.
What's going on with Raphael Solomon? Does he not have an attorney?
He does not. It's my understanding he had an attorney on another file in circuit, and he recently fired that attorney and is seeking counsel.
Okay, we need to bring him up.
Yeah.
Oh, he should be on Polygon.
He should be.
Okay, Mr. Araujo, you're all set. Your attorney says you're continuing to exam.
Okay, thank you.
You're welcome. Be seated. Okay, and that's what Solomon on, I presume. on the record in the matter of the people of the state of Michigan versus Edward Zick, file number 24-01127. Counsel appearance.
Abigail Wilson with the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Zick, who appears today via telephone from the Union County Jail.
Okay, today was the date and the time scheduled for a probable cause conference, domestic violence, burden, and assault with a dangerous weapon. Matter is scheduled to proceed to exam before Judge Flores on May 16th at 9 o'clock in the morning in person at the court. Are we continuing to examine?
I believe so.
Yes, Your Honor. At this time, we're leaving the matter set for an exam, and my client has requested that I address that.
You can do so at this time.
Thank you, Your Honor. I am simply asking that the court consider a reduction either to a personal recognizance or a lower 10% bond. If the court has concerns about safety, I would suggest that the court could, with grant funding, provide a GPS tether. Mr. Zick does have alternative housing. He can reside with his uncle at 915 Riverview in Lansing. Mr. Zick is self-employed as a mechanic, and so he does have stable work or employment if and when released. I will also point out, Your Honor, that this was a date of offense from back in October, and Mr. Zick was just recently in the Ingham County Jail as recently as April, the first week of April of this year. And for whatever reason, the complaint in this case was never pushed through until after Mr. Zick was released. I think had he known about it, we would have addressed this long ago. I will also say, and I know Ms. Wilson has a response to this, but I will also say, Your Honor, for what it's worth, that the complaining witness in this matter has been just relentlessly contacting my office. I've not personally had any contact with her, but relentlessly contacting my office, asking for this matter to be dropped. We just advised her to speak to the Ingham County prosecuting attorney. But for all of those reasons, Your Honor, I would ask that the court consider a reduction.
Counsel.
Thank you, Your Honor. This is two assaultive offenses, and Mr. Zick does have a history of assaultive offenses. I think that the bond is appropriately set currently, and I will note that Mr. Zick has been contacting the victim from jail as early as 8:47 this morning. So I don't think that a reduction in bond is appropriate at this time.
I just learned of that about 30 seconds before we started this hearing, Your Honor. So I was unaware of that. I have no proof of that. I'm certainly not saying she's lying, but I'm just saying that's not a thing I'm ready to address because I've just learned of it.
Not that the prosecutor would be lying about jail calls,
I agree.
but nonetheless, the bond was set at 50,000 cash surety by Judge Ward, I believe, at the time that she arraigned him. At the time she arraigned him, she had more information before her than I did. She had his full and complete criminal history. I do have a bond recommendation that has portions of his criminal history, including that he has prior criminal convictions, home invasion, tampering with an electronic monitoring device, and attempt stolen property. This is charged as a domestic violence third, which means that he's previously been charged and convicted of assaulting and battering someone. These allegations, as alleged, involved a use of a dangerous weapon. I think that the information that you're providing, which is that there's phone calls to the public defender's office from the alleged victim requesting these charges to be dropped, would have a different impact if it wasn't coupled with the fact that there's been also calls made from the jail to this victim, and that might be what's prompting the relentless phone calls. If there's allegations that he threatened to kill the victim or her family, it's very serious allegations. I think the bond was set appropriately. The bond motion is denied. Matter will continue to examine any additional matters for the record.
Last speaker, Your Honor.
In addition to that, I'm going to remind the defendant of his bond conditions because the allegations stated on the record by the prosecution would constitute a bond violation, which is a contempt of court. And so you were advised at the time of your arraignment that you were not to have contact directly or indirectly with Adina Moon, and that you were not to be within 2,000 feet of wherever she was. Allegations have been made that you've made contact from the jail, which is a recorded call. And so if evidence is produced to sustain those violations, you can be sentenced for violating a court order. Contempt of court is punishable, maximum penalty 93 days in jail and or up to $7,500 in fines. Do you understand your bond conditions, and do you understand the allegation of the bond violation?
Yes, Your Honor. May I speak?
No, you may not. You need to listen.
Yes, ma'am.
I think there might have been a breakdown in your understanding of your bond conditions if there's allegations that you've made phone calls from the jail to the alleged victim. There also must be some breakdown because I'm pretty sure that phone told you there was a recorded phone call. So you should have known that the prosecution would likely be able to find out if you're violating the bond conditions. Do you have any questions about your bond conditions?
No, I don't, Your Honor.
Okay, now you have something that you want to say?
Yes, Your Honor. On the day that they picked me up or whatever, from 616 Bluff Street, I've been released to her house. I've been there since March 11th, when I got out of jail with our other case that I had with you. And Your Honor, if the prosecutor goes back and listen to those phone calls, they can see that.
Hold on. I would prefer that we not be talking about jail calls on the record as well, because it's potentially an admission. Mr. Zick, my concern in what you're stating is that if you start making comments about calls that are jail calls while we're on the record, that could be used against you to prove a bond violation against you. So you could be admitting to contempt of court. So my legal advice to you is to not continue with this conversation.
Yes, sir.
Thank you.
That understanding, do you have anything else that you want to say?
No, you guys have a blessed day.
Same to you.
Thank you.
You're free to go.
Is it good for you to what?
You're all set. Let the deputy know that you're free to go so they can put someone else in that room.
All right, thank you. Maybe you have a blessed day.
Same to you. On the record, in the matter of the people, I think both of these people are in custody. Who is this over here from the Department of Corrections?
Yeah, it's Mr. Laquan Jackson, with Mr. Carter as his attorney.
On the record, in the matter of the people of the state of Michigan versus Laquan Jackson, file number 19-02673.
May I approach?
You may. Counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
At Police Court, David B. Carter Jr. on behalf of Mr. Jackson, who is present standing.
Okay, today was the date and the time that was scheduled for preliminary examination, but we said we would treat today as another probable cause conference because Mr. Carter had recently been retained on this matter. How are we proceeding today? It's going to be a plea?
Yes, Your Honor.
That is correct, Your Honor. I've had the opportunity to discuss this matter with my client at length. I've had an opportunity to discuss with him the offer that the prosecution has given him, and my client wishes to proceed with that offer and plead guilty to the lower, to an added count of larceny between 200 and 1,000. It's also my understanding, although it's not on the plea sheet, that there's no objection to immediate sentencing.
That's correct. There's no objection to immediate sentencing. And there's no restitution in this file.
The victim?
The victim in this case would be the bank that the fraudulent checks were attempted to be used or attempted to be cashed at.
You have more information about this than I have. There is an allegation of fraudulent checks. Were these checks allegedly stolen from someone?
They were, we just don't know who did the actual stealing of the checks.
Says the victim and complaining witnesses of Douglas Patton.
Yes, so that was the, I
It's our
guess,
bank.
the owner of the checks. But,
Dana Patton and Douglas Patton had their checks stolen allegedly,
yes,
so we can't have immediate sentence without a victim.
my apologies.
Okay. Nonetheless, you want to plead to the,
I wanted to plead and get sentenced, but since it can't be, well, yeah, I still want to plead and try to get it over with as soon as possible.
okay, you want to accept the offer? I don't have any concern about your time frame. That's not my concern.
Okay.
Okay,
Yeah.
my concern is whether or not you want to accept the offer.
Yes, I would accept the offer.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Okay, the offer again is for you to plead guilty to an amended count one of larceny, $200 or more, but less than $1,000. In order to do that, you would have to give up multiple rights, and I do have an advice of rights and plea information sheet with today's date on it. Is that your signature?
Yes,
Okay, and you read over these rights with your attorney, correct?
yes, ma'am.
And you're willing to give up all of those rights today?
Yes, ma'am.
You understand that you have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. That's a right that you want to give up?
Yes, ma'am.
Okay, you have the right to confront in court and cross-examine any of the witnesses that are called to testify against you. You have the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. You have the right to remain silent and not have silence be used against you at your trial, or you can waive silence and testify on your own behalf. You give up all of those rights.
Yes, ma'am.
Anybody threatening you to get you to give those rights up?
No, ma'am.
Has there been any promises extended to you that get you to want to waive those rights?
No, ma'am.
You're in custody at the Michigan Department of Corrections until when?
Until next week, Tuesday, but since I can't get sentenced, I guess until we get sentenced, I guess. You know, I'm kind of past my ERD already.
Okay. Is that a alleged offense from 2018?
Yes, ma'am.
Pleading guilty because you believe you're guilty.
Yes, ma'am.
And you understand that a guilty plea could result in a conviction that you may need to report on a future job application.
Yes, ma'am.
Okay, and also a guilty plea could have impact on where you can travel or get immigration status. So you may not be able to travel to certain countries with this type of conviction. You understand that?
Yes, ma'am.
As to the amended charge of larceny, 200 or more, but less than 1,000, how do you plead?
Guilty.
Factual basis.
May it please the court. I actually don't have the complaint in front of me. I'm sorry.
I am Whitney Ransom.
Your Honor, I have discussed this matter with my client. He'll be putting the factual allegations on the more serious count of lettering and probation. Oh, this is yeah. Mr. Jackson. How to move your screen up. All right. That's good. Sure. You just
Use two fingers and slide up.
Okay. Mr. Jackson, on October 24th of 2018, were you at 6336 South Cedar Street in the city of Lansing,
Yes,
County of Ingham?
yes,
And at that time, did you hold an instrument that was a check in amount of $747?
yes,
And it was drawn on PNC Bank?
yes, sir.
It had you listed as the payee? Is that correct?
Yes,
And the drawer was Dana Patton, is that correct?
yes,
You had no legal right to have this check. Matter of fact, you speculated that you knew it was a false check, isn't that correct?
yes,
And you tried to pass that as a true check signed by Dana Patton, isn't that correct?
yes,
Thank you. That check was not cashed and PNC Bank did not give you any money, is that correct?
yes.
Thank you, Your Honor. I have no further questions.
Any additional questions from the prosecution?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I will accept your plea of finding a plea to be made freely, voluntarily, and intelligently. Does the prosecution had any contact with the alleged victim?
No, Your Honor, we've not. We've attempted to make contact, but I haven't been able to actually speak with anybody.
He's supposed to be released, it says to the ERD on the 15th, and we'll go to housing where?
Livingston County.
Oh,
He won't be released.
Yeah, I-
Suspended.
she's not had contact with the alleged victim. This is a 2018 case. I'm gonna credit him time served.
Thank you, Your Honor.
Any additional matters for the record?
Nothing for the people.
Nothing for this. time.
You're all set.
Thank you.
Who's in the jail?
Only Your Honor.
Can you hear me in the jail?
Yeah,
What's your name?
Palmetier.
On the record in the matter of the people of the state of Michigan versus Ronald Lee Palmetier, file number is 24-01220, council appearance.
Abigail Wilson for the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Palmetier. He is with us via Polycom, coming from East County Jail.
Okay, today was the date that was set for probable cause conference before Judge Tony Flores. This matter is scheduled for preliminary examination before Judge Flores, May 16th at 9 o'clock in the morning. Are we continuing to exam?
Thank you, Your Honor. Yes, I believe for now we're leaving it set for exam. Mr. Milks has expressed some concerns to me that may change that, and he will let me know ahead of time whether witnesses need to be called off before that date.
Your Honor, that is complete and accurate. People have been very accommodating to us at this time. We will let the people know that whether or not we plan on running the prelim or whether they can call off the witnesses at that time.
I'll note this will continue to exam. Any additional matters we need to address on the record today?
Not for the people.
No, Your Honor, nothing for the defense.
Thank you. You're all set, Mr. Palmetier.
Thank you, Your Honor.
I think she just stepped out.
That's what they said last time. Alex.
She was here until about 30 seconds.
Next time you see her.
Your Honor, the
Well,
front row looks
There's
like
only
the usual
two
suspects.
judges, there's only two judges on the bench today, and I'm doing 2 dockets.
Understood.
I need her here.
Sorry, I can grab her. Yeah, or- I can grab her.
No, it's been warned against that.
other judges?
This is only me, myself and Judge Ward are the only two running the docket today. On the record in the matter of the people of the state of Michigan versus Calvin Thompson, file number 24-00886. Why counsel clearance.
Good morning, Your Honor. Jennifer Lawton on behalf of the people. Aaron Robinson, Assistant Public Defender for Mr. Thompson.
Mr. Thompson present.
He is not present. It is my understanding that I believe he called the court earlier and stated that he's going to be late. I just found that out right now.
He called Sylvia and said he lost his instructions and was gonna be late. That was a while ago, so.
Yeah, looks like on the 23rd, he mixed up and overslept, so he was late then too. I'll show you warrant. Maybe that'll help him keep up with instructions in his court time. A matter is scheduled for exam before Judge Flores, May 16th at 8:30. Are you expecting to continue to exam?
I thought you issued the bench warrant, Judge.
I am going to issue a bench warrant, but have you spoken to him already?
I have not, no. He did call me and leave a voicemail, but I haven't spoken to him directly. He has had contact with me.
Okay. There's also a stipulated order to disclose and protect confidential records in this file. Do you want this addressed now or wait to see if he comes?
Your Honor, if the court would be willing to sign that now, then I can still get that discovery over to Ms. Robinson. The people would request that this matter, if the bench warrant is going to be issued, that this matter not continue for exam next week, so I don't have to call any child victims unnecessarily.
Okay, if he appears later, we'll contact your office to see if you can log on Zoom, okay?
Thank you.
In the jail.
That's Mr. Fisher, Your Honor. We're just gonna, we're probably, we're just gonna leave that out. Well, he's supposed to.
Can you hear me in the jail?
Yeah.
Yes, Your Honor.
Mr. Palmer, you're all set. You need to let the deputy know you're free to go.
Thank you.
Okay, thank you. Who is in jail, post 1? Your name, sir?
Tyler Fisher.
Okay, you say you're continuing?
Yes,
You
Your
don't
Honor.
need to go on the record?
No.
Okay, your attorney said you're continuing to exam, so you're all set. Mr.
Okay.
Mr. Fisher, thank you.
Yeah,
You can
yeah.
let the deputy
Yeah.
know you're all set.
Thank you.
No problem. Is Blackman present, Mr. Starks? Shatori Blackman?
I'll try to follow again, Your Honor. I thought she was gonna try to appear by Zoom. I have a plea offer I really need to talk to her about, so I prefer just to leave it on for now when she shows up. And then we'll follow up with and see if we're actually gonna be one of these exams. Early next week, and we can just leave it on. But I thought she was gonna try to appear by Zoom.
Okay, she's not appeared via Zoom. It's 9:30. She's supposed to be at 9:30, so we'll give her some more time.
Thank you.
You also have, is it Vincent Home?
Yes, Your Honor.
Are-
He's in custody though, and we're just also gonna leave that one on.
Okay, you don't need to go on the record for that one.
Correct.
Very good, thank you.
Thank you.
Who's on, Heredia? Besides Mr. Silverman.
I believe that's Ms. Petrosky.
Well, I know it's Mr. Trosky. I'm asking for the defense
Yes.
attorneys. He has 3
Oh.
matters. Are you handling all three of those?
I'm handling the PE. I think that I am aware what Mr. Lee is wanting to do for his 2 misdemeanors.
Okay, is he downstairs? Okay. You can have him brought up. Okay, on the record, in the matter of the, we need Ms. Petrosky, where did she go? Ron Bledsoe present.
Yes. I'm representing him for Aaron Schroeder, he's out in the hallway right now. Sorry.
So for the record, in the matter of the people of the state of Michigan versus Ryan Lee Wack, file number 23-03515, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Issa Hadad standing in for the Attorney of Record, Edward Zick, for Mr. Ryan Wack. With permission of Mr. Wack, is that correct, sir?
Yes, sir.
Thank you. Please state your name for the record.
My name is Ryan Lee Wack.
Thank you, Your Honor. We are ready to proceed.
Okay, today was the date that was scheduled for a preliminary examination. How are we proceeding?
It's my understanding that Mr. Wack will be accepting an offer from our office of pleading guilty to an amended count 1 of controlled substance use. And I have a filled out plea sheet here.
Yes.
That is correct, Your Honor.
Okay, that's correct, Mr. Wack.
Yes, yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Okay, you can put your hand down, sir. People are offering to amend account 1 to controlled substance use. In order to accept that offer, you would have to understand certain rights and then give those rights up. First, you have the right to the presumption of innocence. So you are innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You can waive your silence and testify at your trial if you'd like, or you can subpoena witnesses to testify on your behalf. And you have the right to present evidence at trial that you believe show a defense to the charge being brought against you. You understand all of those rights?
I do, Your Honor.
Do you wish to give them all up today in order to plead guilty to the amended charge of use of a controlled substance?
Yes, ma'am.
Has anybody made any threats to you to get you to give up your rights?
No, ma'am.
Has there been any promises extended to you to get you to give your rights up?
No, ma'am.
Okay. Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application.
I do, Your Honor.
A conviction of this kind could also have impact on travel or immigration status that you may be seeking. Do you understand that?
I do.
As to the amended charge of use of a controlled substance, do you plead guilty, not guilty, or stand mute?
Guilty, Your Honor.
Are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Factual basis, please.
Thank you, Your Honor. On May 22, the date was May 25th, 2022, in the city of Lansing, county of Ingham, state of Michigan. Did you use a controlled substance?
I did.
Did you have permission to use that controlled substance?
I did not.
Did you have any lawful authority to use that substance?
I didn't. No, sir.
Okay. And you knew it was unlawful to use that controlled substance?
I did.
Thank you. No further questions, Your Honor.
And none for the people.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. This matter is scheduled for sentencing July 11th, 2024. You need to report to our probation department no later than Monday, 9:30 in the morning in person, so that they can get you scheduled and set up for your pre-sentence interview, okay?
Thank you.
Okay.
One thing is Mr. Zaney is asking that he has an evaluation set up with Dr. Deb Smith for and we would submit that to probation. So we ask that that be allowed and not be part of the probation PSI. We're going to do that prior to his full interview.
He's going to be required to do a substance abuse assessment. If he has one that he can provide, that is on his expense, then he's going to do that. Otherwise, he'll do one with the probation department and they will bill him for that. But he's completely allowed to go and get an assessment from an approved assessor and have that provided.
Thank you very, very much, Your Honor.
No problem. So don't forget though that you do have to report to probation in person within 48 hours, okay?
And where do I do that at?
They're in City Hall on the 5th floor.
On the 5th floor. All right. Thank you.
Thank you, Your
You're
Honor.
welcome.
Everybody have a nice day.
Yes.
Do you have any questions, Mr. Wack?
No, ma'am.
Okay, any
Thank you.
additional matters for the record count?
Nothing for the people.
Have a great day.
Yeah, everybody's gonna calm down and let me decide when the case is free to go. Okay, anything else from you, counsel?
Nothing from the defense, Your Honor.
Thank you. Now you're free to go.
Thank you,
It's
Judge.
already- Thank
Have a
you.
good day.
Thank you. I have someone in the jail. What's your name?
Raphael Solomon.
He is unrepresented.
Mr. Solomon. On the record, in the matter of the people of the state of Michigan versus Raphael Solomon, file number 24-01050. Council, may I have your appearance?
Abigail Wilson, people.
Okay, and then Mr. Solomon is present via polycom from the Ingham County Jail. Mr. Solomon, I have here that you were previously arraigned by Magistrate Milmore back on April 27th, at which time you declined court-appointed counsel. What's your plan for representation?
David B. Carter.
Are you hired, or you're intending to hire Mr. Carter?
Yes, ma'am.
Okay, is Mr. Carter aware of this?
Yes.
Because he's present in the court today, he didn't mention anything about your case.
Right, I haven't given no deposit yet. I'm still working on
You
it.
haven't done what?
I haven't paid him yet. I'm still working on it.
Okay, when do you intend to pay?
Like a week or two.
Say that again so I can hear you.
Like a week.
Okay, so this matter is currently scheduled for a preliminary examination on May 16th before Judge Flores will treat that as another probable cause conference so that you can address the timeline and any issues as it relates to discovery if Mr. Carter is arraigned, okay? I mean, retained, that is, okay?
Thank you, Your Honor.
Okay.
Do you have any questions today?
No, ma'am.
Any additional matters for the record today?
Talk to the people.
You're all set, Mr. Solomon.
Okay.
You can let the deputy know that you're done. I'm noting here, that was your file. He's not planning on paying Mr. Carter if he retains it for at least a week, so he doesn't need to be brought over. He can appear via polycom. Mr. Heredia?
Yes.
On the record, in the matters of the people of the state of Michigan versus Antonio Heredia, I have file numbers 18-05847, 24-01168, 24-01171. Council appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Wayne Silverthorne on behalf of Antonio Heredia, who's standing at counsel table to my right.
Okay, Mr. Heredia, I have you scheduled today for a preliminary examination on the felony file, and we reset the 2 misdemeanor files to be addressed today as well. How are we dealing with these?
So it's my understanding that on the for the case that's set for preliminary exam for today, that Mr. Heredia will be waiving the preliminary exam, and people would also unconditionally surrender and ask that the case be found over as charged. And in regards to his misdemeanor files, Mr. Lee, his representation on those files was double booked. He's doing walk-in arraignments today. But I've spoken with him, and he's been in communication with Mr. Silverthorne. And so for both, there's been an offer conveyed for the case involving the DWS charge, where if Mr. Heredia is able to get a valid license, he would dismiss for compliance. And then for the misdemeanor MDOP charge, the events surrounding that are related to the events in the felony file that he'll be waiving up today. So that will we'll be asking for adjournment, so that could be worked into some sort of global resolution on the file.
Those, I would affirm that those are correct statements, and I would note that Mr. Heredia is going to be remaining on the docket in some fashion. Anyway, at least till June 28th, which is sentencing for his for another case. Okay. So
June 28th, he has a case before me.
he's a sentencing.
So you
He
want
pled guilty
the
last
misdemeanor
week.
set to June 28th?
Pardon?
You want the misdemeanor set to June 28th, or?
Or anytime in between then. I would think would be enough time to resolve them. My guess is that that one misdemeanor, as was noted, is related to the others, will probably be folded into that case and dealt with all, because they're all county cases.
Okay. Let me get the date for the misdemeanors. We can do it before. Sentencing on the MDOP.
Yes.
Yes.
Okay, Mr. Heredia, you understand that you have the right to have a preliminary examination in your felony file here in the district court. Understand the purpose of the preliminary examination?
Yes, ma'am.
You have the right to require the prosecution put forth evidence to establish that they have sufficient probable cause that these crimes were committed, and sufficient probable cause that you committed these crimes. You understand that?
Yes, ma'am.
You're being charged with it's like 8 felony counts. With an habitual offender 4th offense notice, enhancing your penalty. You understand that?
Yes, ma'am.
Anybody threatening you to get you to waive your exam?
No, ma'am.
Any promises being made to you to get you to waive your exam?
No, ma'am.
You understand the waiver is unconditional, and you're not going to be able to change your mind if you get over to the circuit court and you don't like the resolution being offered to you.
Yes, ma'am.
Bind over date is going to be May 22nd. That's the date the circuit court's going to get the file from the district court. You do not need to appear in the circuit court on May 22nd unless Mr. Silverthorne files a motion for you to be rearranged at the circuit court level, okay?
Yes, ma'am.
Otherwise, your next court date will be a pre-trial and circuit court. Your attorney will be made aware of that date.
Yes, ma'am.
Have any questions?
No, ma'am.
I will set at 100,000 cash surety. That will continue. Any additional matters for the record?
Nothing from the people.
Let me put your dates on the June 1, 18, June 18th at 1:30, 8:30 on both of the misdemeanors, okay? Any additional matters for the record?
Nothing for the people.
Nothing for the defendant. Thank you, Your Honor.
Thank you, you're all set.
Yeah, yeah. Yeah, I spoke with her.
And Your Honor, just so you know, I see Mr. Willis is on Zoom. I believe he's unrepresented as well.
Who's in the jail? Can you hear me in the jail?
Yes, ma'am. This is Kane
What's your
Alvarez.
name? Okay. Alvarez. That's our doc. Okay. On the record in the matter of the people of the state of Michigan versus Kane Montana Alvarez, file number 24-01053, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Mark Shire on behalf of Kane Alvarez.
Okay, Mr. Alvarez was set for a preliminary examination, but I do have a note that we would treat today as another probable cause conference. Because the attorney had a conflict. Counsel, how do you want to proceed on this? Do you want to continue to exam?
Is there any way I can talk to my attorney for a quick second?
Well, we're on the record now. You've not spoken to your attorney yet?
I have yesterday, but I was under the assumption because I had took a plea to get this dismissed, and I don't know what's going on. I just wanted to try to figure out what was going on.
Was there an offer on this?
Yes, Your Honor. This case is part of a global resolution that's currently, or with a case that's currently in the circuit court. I don't have all of the intricacies of the offer, but basically once he successfully pleads guilty and is sentenced on that file, then people would be dismissing this file. And I believe Mr. Scherer was intending to ask that the next prelim date or PCC date be adjourned until after the sentencing date so that we could just handle this matter once basically the other case had been resolved and worked through.
Okay, Mr. Alvarez, does that answer your question?
Yes, ma'am.
Okay, very good. Okay, so when is his next court date on the matter in the circuit court?
He is set for sentencing on June 24th.
Okay, so Mr. Alvarez, in this matter, you're being charged with felonies. You have the right to have a preliminary examination within 21 days of the date of your arraignment. Due to the fact that you are negotiating and working through a global resolution, which would ultimately result in the dismissal of this case, are you willing to waive the timeline so that we can reset this until after your sentencing?
Yes, Your Honor.
June 27th at 9:30. Do you have any questions at this point, Mr. Alvarez?
No, Your Honor. I would just like to talk to my lawyer for 2 seconds, if that's possible.
Yep, I can put you in the private meeting room in just a moment. Any additional matters for the record, counsel?
Just to clarify, the June 27th date, is that set as a PCC or a prelim? I mean, hopefully all goes well and we'll be able to dismiss the case and it won't be an issue, but just in case something falls through, I just want to make sure we have.
I'm gonna set it as a prelim, but it's up to you if you need to call witnesses or not.
Understood, thank you.
If it doesn't go through, I would imagine we're running an exam, but. Any additional matters for the record, Mr. Chair?
Yes.
What is the additional matters?
No, I'm sorry. I'm satisfied with the new date.
Oh, okay. Thank you. I'll put you and your client in a room.
Okay.
On the record in the matter of the people of the state of Michigan versus LaKendrick Willis, file number 24-01249, counsel appearance.
Abigail Wilson for the people.
Okay, and Mr. Willis, can you unmute your device?
There you go. Yes, ma'am.
Okay, state your name for the record, please.
LaKendrick Willis.
Okay, and you're present via via Zoom. Today was the date set for a probable cause conference before Judge Tony Flores. The matter is scheduled for preliminary examination on May 16, 2024 at 9:30 in the morning. At the time of your arraignment, you declined court-appointed counsel. Are you intending to hire an attorney?
I have already obtained counsel. His name is Mike
Did you
Mavaloni.
You paid him?
Yes, ma'am. And I didn't catch the part you said the time. I got May 16th for the prelim or next.
May 16th at 9:30. That was the same date and time they gave you at the time of your arraignment. You would have received notice to appear for that.
Yes, ma'am. But I gave him some paperwork. Yeah, I don't have it in front of me.
Okay. So Mr. Mataloni has not yet filed an appearance. I'm assuming he'll do that and then he can get his discovery. Otherwise, we'll see you in person before Judge Flores on May 16th at 9:30, okay?
Yes, ma'am. Thank you.
No problem. Any additional matters for the record, counsel?
Top of the people, thank you.
You're all set.
All right, have a good one.
Thank you. Have we seen Shatori Blackman?
Oh, Your Honor, when I try to call her, it goes straight to voicemail and I try to email her. I'm hoping she hears my.
Okay, I'll issue a bench warrant on that one.
Thank you, Your Honor.
No problem. You said Johnny Barney is present?
Yes, Your Honor. Barney is present out in the hallway.
Okay, on the record in the matter, the people of the state of Michigan versus Johnny Barney, phone number is 23-03790. Appearance for the record.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Aaron Schroeder for the defendant Johnny Barney, who is present and standing to my right.
Thank you, Mr. Barney. Today was the date set for preliminary examination. So how are we proceeding?
Your Honor, I sort of busy morning. I haven't, one of my officers is present and I'm not sure if the other officer is present or not. I believe that it's going to impact Mr. Barney's decision. This was Wilson just stepped up to see if Officer Simmons was present.
All right, Your Honor, at this time, we'll be waiving the preliminary exam and have this bound over to the circuit court.
Is there an offer?
At this time, I believe all negotiations or offers need to take place in circuit court.
Okay, and so Mr. Barney, understand that you have the right to have your preliminary examination here in the district court, correct? You understand that you're being charged with one count of carrying a concealed weapon. You have the right to require the prosecution put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yeah.
You're willing to unconditionally waive your exam?
Yes.
Anybody threatening you to get you to do that?
No.
Has there been any promises made to you to get you to waive your exam?
No.
You understand that the waiver is unconditional. You can't change your mind once you get to circuit court if you don't like your offer.
Yes.
On your waiver to be freely and voluntarily given, your bind over date's gonna be May 22nd. You do not, however, need to appear in court on May 22nd unless your attorney makes a motion for you to be rearranged, okay? Next court date will be a pre-trial in circuit court, okay?
Yes.
We set at 5,000 personal recognizance. Actually, it was 10,000 personal recognizance as of the 24th. That will continue. Any additional matters for the record?
Nothing from the people, nothing for defense.
You're all set, sir. The record in the matter of the people of the state of Michigan versus Darius Coleman, file number 24-00402. Counsel appearance.
This is the prosecutor, Paige Petrosky, on behalf of people.
Mr. Coleman.
Yes, yeah.
Good morning. You're okay, Mr. Coleman. Today was the date that we reset your matter for preliminary examination. Are we continuing to examine?
You know, I have a short request for a short adjournment. My friend lives in Detroit. He was released from jail, and I think that we do not have a phone, so we just met this morning and we planning to go after for today at the office to discuss the case, so we can get ready and prepare for the preliminary exam.
I'm not following. Were you new on this case?
No, I'm not new. He was in jail. I think we waived the 21 days of the court found good cause last time.
I found good cause back in February.
Yes, yeah.
He was in Oakland County.
Yeah. And
they don't allow attorneys to visit their clients in Oakland County.
He was released. We lost. He could not contact me, and we only have contact this morning at 5 o'clock.
He's been in Oakland County. He was in Oakland County at the PCC in February. It's May.
I got out April 11th.
That I recollect. I know you did. That's what my notes say, that you were released April 11th. My question is why your attorney didn't go see you between now and then if we were having an exam.
I had no contact for him when he was from jail.
He wasn't released until April. We were supposed to have this exam in March.
And we was supposed to meet and review all the discovery, including the video. And he told me also that his phone, they still have his phone, so he had no way to contact me, and until this morning.
You don't have your phone?
Well, basically, but I don't even know how can I go about getting it.
I can tell you how you go about getting your phone. I don't know who they is. Oh, it was seized for investigation is what you're saying?
Yeah, they never give it back.
Talk to your attorney about how you get it back. Okay, let's see. And your witnesses were here?
They were. I'd spoken with Ms. Wanji earlier, and she explained the situation, so I did release them, given that she wasn't able to see today. But everyone was here.
And if you're sure you wait until I tell you to release, because my note says you accidentally released someone before. So
yes, yeah.
So we don't release until the judge resets.
Understood.
So that there's no issues in the future. So we have to reset this once again. It's your responsibility to meet with your client, whether he lives in Detroit, whether he's in custody of Oakland County. He's been in Oakland County, at least he was, in February. We brought him here multiple times for an exam. So I do think it's actually unreasonable that you're not prepared, because he was in Oakland County and you could have gone to Oakland County to meet with him. He wasn't released from Oakland County until the 11th, but we were supposed to have this multiple times. We had him written here for that purpose, at least on March 15th, which is when she accidentally released her witnesses. We will reset it, but that is not a toll that will be charged to the prosecution. You understand that? You understand that? Okay.
You say it's so charged.
I mean, the timeline. So you have the right to have a speedy trial. And if they delay it, that goes against your right to speedy trial, but this is not their delay. Okay? July 25th at 9 a.m. Do you have any questions today? So you're outside and you don't have any way for anybody to get in contact with you, is what you're suggesting.
Fine. Well, I gotta keep it back in.
How is your attorney supposed to get in contact with you?
She got somebody.
Okay, someone who can track you down?
Yeah.
Okay. Did you make an appointment for a date and time that you all are gonna meet when you step out of here? Or does she just gotta start waiting to track you down after you walk out of here?
No, she said it was coming up
Okay, sounds good. Any additional matters for the record?
Nothing for the people.
We'll get you your notice to appear. You're all set.
Thank you.
No. On the record in the matter of the people of the state of Michigan versus Daquan Bledsoe, file number 24-01187, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Daquan Bledsoe, who will be momentarily standing to my right. There we go.
Okay, today was the date and the time that was scheduled. Preliminary examination. Did he pay for his GPS tag?
Yes.
That's what I'm signing. Doesn't give me a case number.
I put it in the docket, so I don't know if you mistook it for something that needs to be done. I put it right under his side of the other one.
This?
Yes.
I watched it.
That was sent to for signature yesterday, but I just put it in with the other file since he was gonna be here today.
Well, it doesn't have a case number. What case number is in Knox? It's like these are the ones I just signed. I mean, I just pulled these out to be signed. I haven't signed these yet. Those are to be signed.
Okay, I see.
Okay, here it is. Here. Let's see. City of Lansing versus Saquon Bledsoe, file number 16-02941. Bledsoe, looks like you. $1,095. You both that since 2016. Well, it was more than that. You were supposed to be making payments on it. You look like you were making payments, and then you stopped.
Yeah, I had trouble with my job. Yeah, I think we got laid off at the time.
Okay, but you haven't made a payment since August, so when are you gonna make a payment?
Probably next week.
Probably.
Yeah, I can't make, I just paid on my tether, so it's kind of hard. Hard to make those payments right now. I'll get to work on next week.
How much? Next week, Friday is the 17th, so you'll make a payment of $50 by May 17th.
Yes.
So if you were making monthly payments, you'll make a payment of $50 per month on this by the 17th.
Yes. Yeah, money kind of tight right now. Is it possible we can take each other off?
You can push that one. Let's see, back to the felony file. How are we proceeding?
It's my understanding that Mr. Bledsoe would be unconditionally waiving up to the circuit court, and the people would also unconditionally waive the right to preliminary examination that the case be bound over.
There an offer or negotiations going to continue?
Negotiations are continuing. There wasn't an offer at this time.
Okay, Mr. Bledsoe, you understand that you have the right to have a preliminary examination in this file,
Yes.
and you have the right to require the prosecution put forth evidence to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You willing to unconditionally waive your exam?
Yes.
Anybody threatening you to get you to waive your exam?
No.
Is there any promises made to you in exchange for a waiver?
No.
Over date is May 22nd. That's the date circuit court gets the file from the district court. You do not need to appear in court on that date unless Ms. Donnelly wants you rearranged at the circuit court, okay?
Okay.
And then she'd have to file a motion for that. Otherwise, your next court date will be a pre-trial and she'll be made aware of that date. You stay in contact with her, okay?
Okay.
Okay, let's see. There's a police officer assault, and then there is a domestic violence. Almost at it, 100,000 cash surety with GPS tether, but there's been violations of those conditions. At least allegations of those violations because he was not paying for the tether. Are you making a bond motion at this time?
As Mr. Bledsoe just asked if it was possible for the court to consider removing the tether. I mean, it is an expense that he has to, that prevents him from paying for other things. It's my understanding that the alleged victim did appear today. I don't know if she's still in the hallway, but if you wanted to consider what she had to say,
Yeah, she is present. She hasn't expressed anything to me one way or the other about the GPS tether, but I can bring her if you'd like to ask her. Yes, I'm so sorry. I didn't see it really. So I'm just gonna come back and send it. So. Did you ever try to send it to me?
So she can see you.
Yeah.
Over there with the prosecutor. Okay, what's your name, ma'am? Can you spell that?
SATAITSHIA
Okay, there is a bond condition placed upon Mr. Bledsoe as a result of the allegations that are pending. And one of those conditions is for a GPS tether. For them not to have contact directly or indirectly with you, and not to be within 2,000 feet of wherever you are. There's a request to remove the tether at this time due to the expense. Is that something that causes concern for you? The GPS tether will be removed. The no contact order will continue.
Okay.
Do you have any questions about that?
No, no.
Do you have any questions, ma'am? Any additional matters for the record?
Nothing from people, nothing for defense.
You're all set.
Oh, yeah, here. What Mr. Bledsoe?
Is Nicholas Falsetta present?
Yes.
Okay, on the record in the matter of the people of the state of Michigan versus Nicholas Falsetta, file number 24-00351, counsel appearance.
Attorney Luke Ritter from the Public Defender's Office, here to represent Mr. Falsetta, who is in my right.
Okay, today's the date that is scheduled for sentencing. I do have a pre-sentence report that was dated prepared on April 22nd, 2024. You got a copy of that, counsel?
Yes, Your Honor.
Yes, ma'am.
Do we need to make updates, corrections, or deletions?
Nothing from the people.
Nothing from the defense either.
Okay, you can make allocution.
Okay, thank you, Your Honor. Your Honor, Mr. Falsetta, to my knowledge, doesn't have any type of criminal history at all. He's been working full-time at Altera Landscaping, where he works from generally 7 a.m. to about 5:30 p.m. Monday to Friday. He's already completed his drug and alcohol assessment in this matter. He's had no issues since he's been on bond. I would ask the court to sentence him to a term of probation as recommended, to grant him 7411 status, to give him the opportunity to earn a non-public record. He's certainly willing to do any type of testing or outpatient treatment is recommended to address any lingering issues.
Thank you. Did your client want to make a statement?
No, I'll make that.
Okay. I reviewed the prior criminal history as indicated by you, Mr. Goodrich. There's no prior convictions other than this, which would make him eligible for status under 7411. The court believes that the report and the recommendations are appropriate. I'll adopt the recommendation and be placed on a term of 6 months probation. While on probation, he has the following conditions: he's not to use, purchase, or possess alcohol, marijuana, or controlled substance unless he has a valid prescription. He's not to possess a firearm or any other dangerous weapon. He must obtain and maintain employment. Submit to random preliminary breath testing and your analysis testing fees responsible for the cost of that, okay?
Thank you, Your Honor.
No problem. 7411 status will be granted. There's a $30 per month oversight fee that you're responsible for while on probation. It's a $75 crime victim rights that must be assessed, plus a $50 state minimum cost that also must be assessed. I'll waive discretionary fines. The cost, your total fines cost will be $305, but you'll be able to make monthly payments on that while on probation, okay? There's an advice of rights as to probation. You have the right to request early termination from your probation status. Early discharge, that is, once you completed half the original term ordered by the court, which would be 3 months in this case. Once you complete 3 months without having any violations, you can make a request by submitting a MC 512 form, which is the court's notice regarding eligibility for early discharge form. You can get that off the court's website, or you can get a copy from your probation officer. You would complete that, file a copy on the prosecutor's office, and submit a copy to the probation department. The prosecution has 14 days from the receipt of that to file any written objections to your early discharge. Do you have any questions?
No.
Any additional matters for the record?
Nothing from the people.
No, Your Honor.
You'll go downstairs and check in with probation before you leave, okay?
Thank you.
You're welcome. That was all set up. There's Jones is in custody. Are we running an exam?
I just need to check one last time to see if the victim is here, and if not, that will be a dismissal.
Okay, while you do that, I'll do Brian Knox. On the record in the matter of the people, it's a sentencing. The state of Michigan versus Brian Knox, file number 24-00515. Counsel appearance.
Yes, there was something for the people.
Mr. Knox, today's date set for sentencing, as you have a pre-sentence report and recommendation. It was prepared back on May 3rd. Counsel, did you get a copy of that?
I did.
Do we need to make corrections, updates, or deletion?
None, Your Honor.
Make allocution.
Thank you, Your Honor. My client has started doing everything that was required from him for the operation. He has a therapist addressing substance abuse. He's seeing the therapist twice a month. He also has remained substance abuse free. He has the support of his family. He has kept his job, and this is actually his busiest period on the year of the year. He's working 60 hours per week. He's making good money. He explained to me that he has no need at this time of using. He's keeping very busy, and therapy is helping a lot. So he's taking responsibility for what happened. He does understand that substance abuse has some gosh with the law because of the substance abuse, and he wants to really take care of that. He's also working very hard to get his license so that he could drive because the car is very important for him for his business. Discussing probation, he told me that one of the plans to continue with therapy, even if probation is not ordered if probation is terminated, because he does believe that he needs to take care of the substance abuse, and it's gonna be a long way in order for him to remain sober. That the recommendations are just. However, my take is that with him being so busy, I understand that the reporting is by Zoom. With him being so busy, I don't want to set him up for failure. He needs to get an employment, and if he doesn't work as much as he can for this spring and summer, coming winter time, the income will not be there. He did explain to me when from the report that when during low season, he only brings like 1,100, 1,300 per month. During high season, it's different, and so he's making a lot of money during the busy season. If the court believes that probation is required at this time, we would respectfully request that it be a short probation. And like I say, he's already doing whatever was requested for him and what the probation has recommended, what his assessment had recommended.
So you might want to make a statement.
Yes, Your Honor. I have been doing the things that I've been asked. I've been seeing a therapist at CMH, Lizzie Bryan. I see her twice a week. We have set up a goals list of things that I have to do before I'm released from therapy, including going to get seeing a doctor to get a physical treatment so they can give me like medication legally. Then going to AA or NA classes twice a month as a requirement of therapist, just some of the goals that we set up. And yeah, I'm just looking to put this behind me and move.
This is incident like having occurred back in February of 2024. Not that long ago, correct?
Yes, ma'am.
I'm reviewing your prior criminal history. This is not your first conviction for substances, correct?
Yes, ma'am.
So I applaud you that you're getting some treatment and some outpatient therapy, because it's what you need. You have a pretty extensive criminal history. Someone who's not quite hit 40 yet. You've been involved with the criminal justice system quite some time. You've done probation before, correct? I recognize that you're working now, you're turning your life into a better direction, and I think that that's to be acknowledged, but that does not give the court cause or reason to believe that this is a case that shouldn't have any judicial oversight. This is a situation where it hasn't happened that long ago. You have a prior criminal history that is similar to this type of behavior. And then when we sent you to be assessed prior to your sentencing, it came back that you did have a mild cocaine use disorder, but that it was believed that you could address this by doing some outpatient treatment, which is what you're already doing. But you've just begun that treatment. And so I think it's important that we make sure that you get the tools that you need so that you don't find yourself back here when situations arise that do cause you to feel like you might want to engage in using substances that are harmful to your body. I also see your driving record, and I know you're seeking to try to get your license reinstated. Did you do any OWI specialty court or something when you got your license taken?
No, I didn't. It wasn't required for that. The only thing that I asked my lawyer the last time was I had got a packet that I got to go through. I had to wait a year before I could file to get the license back, and they gave me a hearing packet.
I recognize that. I was just having this conversation with another, well, actually one of Ms. Longy's colleagues about the extensive nature and the uphill battle it is with Secretary of State to get your license reinstated under these circumstances. And it's without, having some kind of substance abuse court, specialty court that you were successful on, it steepens the hill that you have to go up. You're doing the things that you need to be doing, which is you're working, you're in treatment, but they have to see that you have abstained from certain substances for a period of time before they will ever give you your license back. You just got a recent conviction. Something like that could set you back, even though it wasn't involving a vehicle. That's something that they can consider because it doesn't show them that you've made a lifestyle change as it relates to the decisions to use substances. When it comes to even OWIs, they want to see that you're not even drinking anymore, that you decided that you're going to be sober, that you're working, that you have letters of reference and recommendation from individuals that can show and demonstrate that he's changed his life. He's not the same person. You sound like you're on that track, but you're at the beginning of it. So I would encourage you to continue on that track. Probation is appropriate in this because we need to have some oversight. I recognize that you are working. This is your busy season. This is our busy season at the court too, because it's getting warm outside. And so we get to have remote hearings, but sometimes we don't. Luckily for you, for probation, you get to appear remotely to meet with your probation officer. So that should not be a problem. Even if that means that, you have to take a break during your work time and reschedule your break around the time that you have to meet. Make sure you're meeting because again, it's via Zoom. You don't have to come in to do that. As long as you're doing your drops as you're supposed to, you won't have any issues. And then with this term of probation, you have the right to request early discharge after 90 days if you don't violate. So it's not a very long time that the court needs to have oversight. We just need to see that you've committed to being on track and that you're going to continue on that path. So I'm going to adopt the recommendation, which is for 6 months of probation. While on probation, you're going to continue your outpatient substance abuse treatment, and you'll provide evidence of that to probation. So if you're already in treatment, you don't need to go get new treatment because you're on probation. You just provide evidence of that to probation, okay?
Yes, ma'am.
Will be required to submit to random preliminary breath testing and or urinalysis testing. You're responsible for the cost of that. You need to maintain your employment and provide proof of that to the probation department. You're not to use or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription. And you're not to purchase or possess a firearm or any other dangerous weapon. Do you have any questions so far? There is a $30 per month probation oversight fee that you're responsible for. So 6 months of probation. If you do 6 months, we'll make it $180. There's a $75 crime victim rights fee that must be assessed. Plus a $50 state minimum cost that must be assessed. Okay, your fines will be a total $305. You'll check in with probation before you leave. I've already advised you of your right to request early discharge after you completed half the original term ordered by the court, so long as you've not violated within the 90 days preceding that request. You can make that request by getting the court's MC 512 form. That's the notice regarding eligibility for early discharge from probation. You can give it off the court website or you can request it from your probation officer. If you complete that form, you file a copy on the prosecutor's office, and then you also bring a copy to the probation department. The probation officer can make the request on their own, and they would do the same process. If it's set for a hearing to address your request, you have the right to be represented by an attorney at that hearing. You would have to hire an attorney, though you don't have the right to court-appointed counsel for that hearing. Do you have any questions?
No, ma'am.
Once again, you'll go downstairs, check in with probation, and then you'll be all set. And good luck to you. Any additional matters for the record, counsel?
That's for the people, thank you.
Thank you. You're all set. That was not, okay. Ms. Petrowski, you were going to check on somebody.
Yes, Your Honor, I was here to see, or I was checking to see if the complaining victim and Derek Jones was present, and she is not. So
Jones is in custody, correct?
I believe so.
Yes.
You want him brought up?
If the court will allow me to waive the appearance, I'm happy to do so, and I will go down and meet with Mr. Jones myself.
On the record in the matter of the people of the state of Michigan versus Derek King Jones in file number 24-01185, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Jones, who is in custody downstairs. I will waive his appearance for the purpose.
Okay. And today was the date set for a preliminary examination. The necessary witness has failed to appear, correct, counsel?
That's correct, Your Honor.
Okay, so the people are moving to dismiss?
Yes.
Okay, motion to dismiss without prejudice is granted, and as you indicated previously, you'll explain that to your client. Any additional matters for the record?
Nothing from the people.
The only thing I'd ask is if I could have 2 copies of any knowledge signs so that I can provide one to my client in the file. Other than that, nothing further.
No problem. Thank you. And I think, is Whitney Ransom your client?
She is, Judge, and this is supposed to be a preliminary examination today, so her appearance on Zoom is unexpected. I will also say that I've not had any contact with her since the PCC. I sort of feel like this is probably going to be a competency referral, but because I can't really get contact with her, well, it's determining specific issues that need addressing.
Okay, sounds good. Ms. Ransom, can you unmute your device?
Hi, Your Honor.
Why are you not present in person, which is what you were told to do?
I did not know. I know that's my fault for not knowing, but
Okay, well, you need to get here within the next 30 minutes.
I can't make it. I'm sorry. I can make it in 45.
You can make it in 45 minutes?
Yes, I'll get down there.
Okay, we'll see you in 45 minutes.
Hey, can you? Okay, thank you.
Thank you. Thank you. Mr. Etheridge, you have Angela Richardson.
Ms. Richardson.
Okay, on the record in the matter of the people of the state of Michigan versus Angela Richardson, file number 24-00340, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Attorney Derek Edwards from the Office of Public Defender on behalf of Ms. Richardson and Courtroom standing to my right.
Ms. Richardson, today's the date set for sentencing. I do have a pre-sentence report and recommendation. It was prepared back on April 29th. Counsel, did you get a copy?
Yes, Your Honor. Yes, Your Honor.
We need to make corrections, updates, or deletions.
None for the people.
Yes, Your Honor. On page 2, where it says unemployed, she advised me yesterday that she is currently self-employed. She started a painting handy woman business a couple of weeks ago. Has her first job now that she's currently working on. She's hopeful to maybe earn around $500 a week, but she doesn't know for sure at this time.
You said painting handiwork?
Yes, Your Honor, it's called
American Painting and Handling Services. Let's see.
Any additional changes?
Two updates, I suppose, on the second page where it talks about mental health history, I did want the court to know that she was recently hospitalized for 10 days at Cedar Creek Hospital in St. John's. She was having a mental health issue where she was suicidal. She's currently and has been ongoing seeing her psychiatrist every week. They're still trying to get her medications adjusted appropriately. The other update, Your Honor, is she is no longer at the Holy Cross shelter. She advised me that she is living with a friend at 413 Durant's Place, Lansing, Michigan 48912, which she advised me she's already informed the probation department and courts. Additions, deletions, or corrections, Your Honor.
Make allocution.
Thank you, Your Honor. I please the court. Your Honor, I reviewed the recommendation with Ms. Richardson. She believes the recommendation is a appropriate recommendation that would cover the snow factors. Any modifications to the recommendation she would leave up to the court. Your Honor, even though she is not still at the Holy Cross shelter, she still is indigent. She is, for the most part, still suffers some disabilities, including mental health issues, and is currently on public assistance. She would ask the court to consider waiving any fines, fees, or costs the court can waive for her. She did advise me she was able to get the $100 for the assessment fee together and can pay that today. She's taken responsibility for this. She continues to struggle with her mental health issues and her addiction issues. She, as a report points out, a good candidate for probation. She seems to be remorseful. Probation noted that she was cooperative and remorseful, willing and able to comply with the terms. So she would ask the court again to adopt the recommendation and leave to the court's discretion any modifications. Thank you.
Thank you. And did your client want to make a statement on her own behalf?
I am very, like he said, remorseful, and I am able to do probation and pay the fines and fees.
Thank you. Okay, so Ms. Richardson did meet the criteria for a severe opiate use disorder in early remission, along with some other concerns referencing her mental health. The court has reviewed the pre-sentence report and the recommendation, as well as her prior criminal history. We think that a term of probation is appropriate. I think that the recommendation of 9 months of probation is also appropriate, so I will adopt that. While on probation, you need to continue your mental health counseling at Community Mental Health. You'll be ordered to provide a release of your information. You have to sign that so that the probation department can access that information, okay? You would also need to provide proof of all your prescriptions to probation, okay?
Yep.
Probation is recommending that the defendant attend a community therapeutic service at the discretion of the probation officer, so I will order that as well. while on probation. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription, okay? You're to submit to random preliminary breath testing and your analysis testing. You're responsible for the cost of that. You're not to be at any bars or any nightclubs, not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm or any other dangerous weapon. Do you have any questions so far? There's a $30 per month oversight fee that you're responsible for while on probation. There's a $100 assessment fee that must be assessed for the assessment that you had to undergo prior to sentencing. There's a $75 crime victim rights fee that you're responsible for, plus a $50 state minimum cost. 9 months of probation at $30 per month is $270. You owe the Lansing Police Department $422.99 for responding to this incident. It's a total of $917.99. The court has waived discretionary fines and costs, so that still leaves $17.99. And you'll be ordered to make monthly payments on that, okay?
Okay.
Have any questions about that?
No.
There's an advice of rights as to probation. You would have the right to request discharge from probation after you've completed half the original term ordered by the court, so long as you've not made any violations within the 90 days preceding that request. You would make that request by using the court's notice regarding eligibility for early discharge from probation form. That's the MC 512 form. That form is on the court website, or you can get it from your probation officer. You would complete the form. You would serve a copy on the prosecuting attorney's office and on the probation department. The prosecuting attorney has 14 days from the time that you give them that form to respond in writing with any objections. If it's set for a hearing, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel for any hearing regarding early discharge from probation. Do you have any questions about that? You'll check in with probation before you leave here today. Any additional matters for the record, counsel?
Nothing from the people.
No, Your Honor, thank you.
Thank you. Good luck to you, ma'am.
Thank you.
Ms. Donnelly, is Justin Rouse present?
Yes, Your Honor.
Are we gonna run a hearing?
No.
I mean, exam. Okay. On the record in the matter of the people of the state of Michigan versus Justin Rouse, file number is 24-01138. Counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people. Assistant Public Defender Sarah Donnelly on behalf of the defendant Justin Rouse, who is present standing to my right.
Okay, Mr. Rouse, today was the date that was scheduled for a preliminary examination, and counsel, you're stating we're not going to have an exam?
Yes, at this time, Mr. Rouse will unconditionally waive his right to the exam and have it found over to the court.
And the people also unconditionally waive their right to a preliminary exam and ask the case be found over his charge.
Mr. Rouse, you understand the purpose of the preliminary examination?
Yes, ma'am.
You understand that it's your right to have that examination. Right to require the prosecution to put forth evidence that would establish if they even have probable cause sufficient that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am, I do.
You wish to unconditionally waive your exam.
Yes, I do.
Has anybody threatened you to do that?
No, ma'am.
Any promises being made to you in exchange for a waiver?
No, ma'am.
Signed over date is going to be May 22nd. That's the date the circuit court gets the file from the district court. Your next court date, however, will not be that date. It'll be a pretrial at the circuit court unless your attorney wants you rearranged for some reason at the circuit court, okay?
Okay.
She'll be in contact with you about your next court date. Bond was set at 2,000 personal recognizance, and that will continue. Any additional matters for the record?
Nothing from the people.
Nothing for defense.
You're all set, sir.
All right, I'll see you later.
Have we seen Samuel Wilson, or does that continue? That was Flores's matter.
Well, Ms. Wilson just stepped out, so I can go get her real quick.
Oh. Other files. This is for Branch. Oh, was that their briefs? Is that for hearing? The 23rd. Yeah. Let's see what we got. What's going on with Samuel Wilson?
I spoke with Ms. Robinson and he's in line to take our offer. So I think we're gonna convert the prelim date next week to a pre-date.
I'll note that in. Sorry.
We just have Megan Tar, which is an exam that it's my understanding will be running. And then Whitney Ransom, who's the lady who appeared on Zoom.
She just called the administration's office and indicated that she can't be here in 45 minutes, even though she told the court she could be in 45 minutes. Looks like we already had her in warrant status, so I did advise her attorney to try to call her, but
okay,
she doesn't appear today. I am remanding her.
Flores docket.
Ms. Robinson's client, she had not spoken with them?
Correct.
Okay, we can see if Ms. Robinson and the prosecutor on Thompson can appear. He's here.
I can appear in Miss Lawton's stead. She had to go to a conference.
Okay, so the last one we have is Tar, and we are running that.
Unless something's, yes, we are running out.
Are we ready to proceed now?
Yes, we are.
Okay, on the record in the matter of the people of the state of Michigan versus Megan Tar, file number 23-02871, counsel appearance.
Assistant Prosecutor Pete Kristen, on behalf of the people.
Good morning, Your Honor. For the record, Joseph P. on behalf of the defendant, you allowed to step on the record.
I'm sorry?
Yeah, I'd be allowed to bring her in from the hallway.
Okay, yeah.
That's why I'm back here.
Yep, she needs to come in.
Yes.
Okay, today was the date and the time that was set for preliminary examination. This is for count of terrorism, and we're ready to proceed with the examining preliminary matters.
Nothing from the people.
Just ask for the record for a mutual sequestration of witnesses, although my understanding is that people only intend to call one witness.
That's people's intent. We have additional law enforcement witnesses if needed, but I anticipate it'll just be the one witness.
Sequestration is granted. Please call your witness.
Thank you. The people will call Todd Lozier.
I approach her.
Okay, we're gonna go right over here. And raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat. And could you state your first and last name and spell both?
Todd Lozier, TODD LOSURE.
Proceed, Counsel.
Thank you, Your Honor. Good morning, Mr. Lozier. How are you doing?
Doing fine, thank you.
Excuse me. Where are you currently employed?
Mobile medical response,
And how long have you been employed there?
almost 8 years.
Were you employed there then on August 27th, 2023?
Yes, ma'am.
And were you working on that day?
I was on shift.
And what is your job, or what is your job title?
I'm an emergency medical technician, EMT.
And what do your duties include?
Driving, patient care, patient assessment.
And are you oftentimes at various hospitals in the area?
Yes, ma'am, often.
Were you at Sparrow Hospital on August 27th, 2023?
Yes,
And is, to the best of your knowledge, is that address 1215 East Michigan Avenue?
it is.
Is that in the city of Lansing,
It is.
Ingham County,
Yep,
state of Michigan?
yes.
So on that day, did you experience anything that was sort of out of the ordinary for, I guess, what's usual in your line of work?
Several things. Which one are you referring to?
I guess first, when you were outside of Sparrow Hospital, did you have an interaction with an individual with someone who someone who had stated they had a gun?
I did have an interaction with someone who stated they had a gun, yes.
Can you describe how that interaction began?
I was taking my stretcher back out to my ambulance by myself. My partner needed to use the bathroom. During loading my striker stretcher, I heard a horn blaring and looked and seen a car coming down the road. And the car rapidly approached and decelerated and stopped in front of my ambulance. I assumed it was someone that needed emergency care, and it happens pretty frequently. A female exited the vehicle, approached me. I asked if she needed help. Very erratic, yelling, couldn't understand most of what she was saying. I was trying to get her to calm down. This went on for not very long. And finally, she told me she wasn't hurt and didn't need help. And I said, is there someone in your car that needs help? Is someone else hurt? And she said, no, you don't understand. And that's the point in which she informed me she had a gun. Part of the previous conversation when I was trying to ascertain if she was injured was she was telling me she was very upset with the hospital. She thought I worked for the hospital. I was upset the way she'd been treated by them or something to that effect. Gonna get even with all of us, and she was gonna get us, and made it very specifically clear to me that she wanted to clarify that I didn't understand that she had a gun and wanted to kill everyone in the ER
Okay.
of the hospital.
And so when you're having that conversation with her, you said she was sort of acting erratically, but how can you describe her demeanor and how, her demeanor?
Very excited, screaming, yelling, obscenities, throwing her hands and arms around, to the point where it seemed like she was hurt or had somebody in her car that was seriously hurt. She was that upset. Very, very erratic, very hard to understand initially what she was even saying.
But eventually, once you were able to clarify, she informed you that. And so, did she state that she was going to?
Objection leading.
The objection is leading.
I wasn't, but I
okay.
If I could just ask the question, I was good. And sorry, now I lost my train of thought. Give me 2 seconds here. So when you were speaking with were you during this interaction, were you able to see her face?
Yes.
And would you recognize her if you saw her again?
Yes, ma'am.
Is she present in the courtroom today?
Yes, ma'am.
Could you point out where she's located in article of her clothing?
Woman in the blue dress.
Let the record reflect that the witnesses identified the defendant.
Any objection to identification?
Okay.
Identification is noted.
So when you were speaking with the defendant and she's behaving very erratically, were there specific statements that you remembered her saying to you?
I'd prefer to avoid obscenities, but she was very, very vulgar about wanting to harm me, harm others. Stated she was going to get even with everyone. Everyone needs to die. It was very rambling and chaotic and hard to remember exactly. I was able to get her to calm down enough to actually communicate with me. And I do remember one exact phrase was, "You don't understand me. I have a gun." And at this point, I'm like, okay, she doesn't need help. And I said, just wait right here. I'm gonna go find someone to talk to that can help you. And I slowly and calmly went into the building to try not to alert her that I was going to get security. And luckily there was several police officers and security right inside the door. And I immediately informed them that there was a woman outside that stated she had a firearm and that we have an active shooter situation potentially, and that they need to activate the shooter protocol.
And during this conversation with the defendant, did she specifically state how she was going to use the gun, or did she just say she had a gun, was going to use it?
That she had a gun and was going to use it.
Okay. And how did you understand what that, or what did you understand that to mean?
I took it as a direct threat that she had a firearm and intended to use it on me and everyone else in the hospital.
And to the best of your knowledge, did any sort of shooting event occur that day?
No, ma'am.
At Spur Hospital? When you were speaking with her, did you see a gun?
I did not. Okay.
Oh, he has.
Not quite yet.
Sorry.
Cross-examination.
Thank you, Your Honor. After this incident happened, you were interviewed by a police officer?
Yes, sir.
Did you tell him the truth?
Yes, sir.
Did you tell him everything that you remembered?
Yes, sir.
You indicated today that the interaction was quite brief.
Mm-hmm.
Is that a yes?
Is that a yes?
Yes.
I'm not trying to quibble,
Sorry.
but there's a young lady who's going to be taking this down, so they can't take down head nods or.
Gotcha.
Okay, thank you. What you stated to the officer was the entire interaction with Ms. Tara lasted less than 30 seconds. Does that seem fair?
Pretty close to that, probably. Happened pretty fast.
So she drive around the corner honking her horn.
Yes.
Parked in front of your ambulance or next to your ambulance?
Passed and just down by where the police park, she came past the ambulance, and I don't know the distance, but past the ambulance, yeah.
She got out of the vehicle?
Yes.
Said she was yelling, screaming?
Came running up, yeah.
Did you notice what she was wearing?
Not much. I think it was some kind of bathrobe or hospital bathrobe of some sort. Maybe some kind of hospital brief and a bra.
If you reported to the police that she was only wearing a bra and an adult diaper, would that refresh your recollection?
Yeah, that sounds about accurate.
You believe that to be accurate?
Is that a yes?
Yes.
All right. You've been an EMT for 8 years?
I worked at MMR's EMT for 8 years. I've been an EMT since 2012, 2015.
So you've had occasion, I would imagine, to deal with patients dealing with mental health episodes?
Yes.
Well, how many times?
Hundreds.
I believe that you'd be able to recognize, in some circumstances, somebody who might be dealing with a mental health episode.
Yes.
Did you think that that might be what was going
on? There's definitely something psychologically going on, yes.
When you talked to the police, you said that you did not see a gun.
Correct.
And I believe you just told the prosecutor you never saw a gun.
No, I did not.
The only information you have about a gun is what was verbalized to you.
Yes.
You also indicated to the officer no direct threats were made about what Tara would do with the gun, correct?
She said she was going to get even with everybody and had made multiple vulgar verbal obscenities towards me and people that she had dealt with in the hospital.
Okay. Let me interrupt you because I'm asking you specifically about what was said.
Mm-hmm.
You told the officer there were no direct threats about what she would do with the gun, but you felt the threat was implied based on her statements.
Correct.
Is that true?
Yes.
So there was no statement that was made that she was going to do a particular thing with the gun.
No.
No, that's not right, or no, it wasn't said.
Could you ask me
Sure.
again?
Let me back up the question. You agreed with me that no direct threats were made by her, but you felt the threat was implied based on her statements. You said yes. My follow-up question to that was, there wasn't anything that she said specifically about what she would do with the gun, just that she had.
She didn't specifically say she was going to use that gun or a gun to shoot me. She said, you're part of them, you're one of the hospital people, and I'm going to get even with you. I'm gonna get you. I'm gonna get everybody, and then specifically said, you don't understand, I have a gun.
She did, but she didn't say, I'm going to shoot the ER up.
No, that was not her exact phrase.
She didn't say anything about, I'm gonna go into the hospital and just start killing people.
That wasn't what she said, no.
In fact, what you reported to the police is the extent of what she said was she would quote, show them who's boss.
I remember saying that now, yeah.
Okay. Went back in and actually strike that. You were able to get her to calm down.
A little bit, yes.
Was she close to the hospital entrance? Was she closer to her vehicle, closer to your ambulance? Where was she physically?
Pretty close to the hospital, probably right near the police parking area, probably off the right side of my truck, pretty close to that area.
Did you ever make any physical contact with you?
No.
Did you ever see her make physical contact with anybody?
No.
Did you hear her make any other threats other than what you testified to after you got security?
No, I stayed inside the building.
So you went inside and alerted security, correct?
Yes.
Obviously, somebody came out from the security team.
Yes.
And while they were doing what they were doing, you remained inside the hospital.
Yes.
Were you there when they brought her in and admitted her?
No.
As a patient?
No.
Were you aware that that had happened?
I assumed it was going to be the case that she would get admitted, and I believe I heard through the grapevine that she was.
Let me stop because I don't want you to testify about things that you heard.
Okay.
But did you have, you didn't have personal knowledge that they had made?
No.
Doesn't surprise you to find out they.
No.
You said that you alerted security that there was an active shooter situation.
Yes.
What does an active shooter mean to you?
A public threat with a firearm.
Whether or not somebody's actually shooting?
I didn't tell them that there was active shooting in progress. I said we have a potential active shooter situation. And a woman has told me she has a gun, and they immediately went outside.
And that was the extent of it. Again, you never saw the gun.
Correct.
You never heard shots from anyone.
No.
And the extent of your knowledge of whether there was or wasn't a gun is just what you were told.
Correct.
And based on that, you informed that there was a potential active shooter situation.
Yes.
Did you tell any of the police officers that?
That there was a potential active shooter? There was several police officers and security guards standing directly inside the building when I entered. And I told all of them, I didn't speak to any one of them personally, like one-to-one. I told all of them that there's a potential active shooter and that there's a woman outside that said she has a gun.
The police said the police were already on scene.
Mm-hmm.
Sure, yes.
Yes, sir.
This is in addition to the hospital security people.
Yes.
When people went out to speak to this individual, was it the hospital security, was it the police, or was it both, if you know?
I believe all of the security for the hospital and the police went outside.
You weren't present while they were doing whatever they were doing outside because you stayed in.
No, I was not outside. I stayed inside.
I have any more questions? Thank you.
Redirect.
I have no redirect for this witness.
Which jury instruction are you relying on?
It's 38.4, Your Honor.
Yes, I believe specifically the 38.4A about the Communicating.
Questions?
There's two that apply to this statute, 38.4 and 38.4A.
Correct.
According to the complaint that was filed, she's charged consistently with the language of 38. Not A.
I just need more clarification. It's exactly what was said. I hear that it was chaotic and it was erratic, but other than I'm going to get you, or you don't understand what, and that she stated that she had a gun. Was there any other statements made about what the suspect was going to do?
That she's gonna get even with everyone. And when I was trying to ask her what she meant or what she needs, I was really just trying to see if she needed help. That's when she said, no, you don't understand. I have a gun, which led me to.
Any additional questions based on that?
None, or nothing from people.
Thank you.
Thank you, Mr. Lozier.
Thank you.
Any other witnesses?
Just briefly, Your Honor, I'm going to call Officer Sean Rotano.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
Thank you. You can have a seat. Please state your first and last name and spell both.
Sean, Sean, Rotuno, Rotunno.
Thank you, Good morning, Officer Rotano. How are you?
Good morning, how are you?
Good. Where do you currently work?
City of Lansing for the police department.
And were you working for the Lansing Police Department on August 27th, 2023?
Yes.
And on that date, were you dispatched to Sparrow Hospital?
I was not dispatched there.
Oh, were you at
I
Sparrow?
was already at Sparrow.
My mistake. And when you were there, did you respond to a threat made to the hospital?
Yes.
And what was your role in responding to that?
So I was already in the hospital. Paramedic came in, said that there was someone threatening to shoot the hospital that was out behind the ambulance bay. So I responded to see what the situation was.
And did you have contact with the person who was making those threats?
Yes.
And did you speak with that individual?
Yes.
And did she make any statements to you in the course of your interaction with her?
Stated that she essentially was having a panic attack, that she has them often, that she initially said she did not make any threats. When I asked her about it, I asked her if there was a gun in her car. She confirmed that there was and where it was. And then I ended up petitioning her, and on her way into the hospital, she made a statement that she did not mean to make the threats, that she was really worked up, which is why she said the things she did.
And you had said that she informed you she had the gun in her vehicle.
Yes.
And was that gun located?
Yes.
And were you the officer who personally removed the gun from the vehicle?
I observed the gun there. I can tell you I did not tag it into evidence. That was a different officer. And based on that, I don't remember if I physically removed it and handed to the other officer to tag in, or if he physically removed it so he could tag it in as evidence. But I did visibly see the gun inside the vehicle where she had indicated it was.
Did she express to you any ideas or opinions she might have had about the hospital or the hospital staff?
Yes, I don't remember specifically, but generally it was over mistreatment about previous care that she, or an experience she had with the hospital.
When she was discussing her previous mistreatment from the hospital, what was her demeanor?
Definitely angry. Like I said, she was worked up and emotional. But I guess angry over again, the previous care, but it didn't really go into detail what that was, but.
No further questions.
Thank you. Officer, you were engaging in a conversation with her. You said she was upset, but
yes,
she was otherwise cooperative with you.
Yes.
She didn't try to run.
No.
She wasn't physical with you.
No.
Didn't make any threats towards you.
No.
Gave you information about where the firearm was located.
Yes.
That was accurate information.
Yes.
Told you about the condition the gun was in.
Yes.
And that was accurate as well.
Yeah.
Never tried to go back and retrieve the handgun or anything while you were there.
No.
Were you out there with a number of other individuals, or was it just you?
Yes, there was another security officer, and then another officer, police officer had showed up at some point during the interaction.
Did she ever threaten any of the other people?
Not while I was there, no.
Did she ever assault anyone?
No.
You indicated that you petitioned her.
Yes.
So you felt that this was a mental health episode worthy of judicial intervention.
Yeah.
And that was in order to have her stay at the hospital.
Correct.
She voluntarily went with you into the hospital? Or with another officer?
When you say voluntarily, I placed her in protective custody with the intention that she didn't really have an option to leave, but I do believe that she was cooperative in walking into the hospital with me. Like, she didn't fight with me as I took her into protective custody. To, I guess, paint the picture, sorry.
No, don't be sorry. I appreciate the detail. And I'm not trying to put words into your mouth, but she was going with you. As far as you knew, she wasn't going anywhere else. She may or may not have known.
Correct.
But she certainly.
But she was cooperative.
Right. She didn't try to get away. She didn't resist you in any way.
No.
And she ultimately was admitted to the hospital. Were you there when that occurred?
Yes.
So there were no problems with the admission process either.
No.
That no other issues with her at all as far as you were concerned?
No.
Thank you. I'm sorry, I don't have any more questions.
Can you read your record?
No, Your Honor. This witness, yeah, no more questions for this witness, Your Honor.
Okay. I thank you, Officer Vitano. There is a sequestration order, so you're not to discuss any portions of your testimony with any other witness, okay?
Yes, Your Honor.
Thank you. Any additional witnesses?
No, Your Honor.
That's all my witnesses today.
Not for exam, Your Honor. Thank you.
You can make your argument.
Thank you, Your Honor. Ms. Tarr in this matter is charged with one count of making a false report of terrorism. And from the testimony that we heard from the EMT responder, Mr. Todd Lasser, he stated that when he spoke with defendant when he was working as an EMT responder, his testimony stated that this event occurred on August 27, 2023, and that it occurred at Sparrow Hospital, which is in the city of Lansing County, Bingham, state of Michigan. He stated that Ms. Tarr pulled in driving very quickly, and he thought that there was some sort of ongoing emergency happening, and he tried to make contact with her to assess what the problem was and potentially offer help if needed. And that in the course of his discussion with the defendant, that she communicated to him via speaking that she was very angry about her prior treatment with the hospital. And this was also stated to Officer Rutano as well, that she wanted to make the hospital staff pay, and then when he asked for further clarification about what she meant or what was going on, he remembered very clearly, "You don't understand, I have a gun." Now, just stating that you have a gun isn't necessarily a threat. However, taken into account with both her erratic behavior and the and her anger at her prior mistreatment and wanting her stating that she wants to make the hospital staff pay, a reasonable person would interpret that to be a threatened act of terrorism, a threat to shoot up the hospital staff and shoot up the people in that building. It was not made as a joke or as a political comment. It was made to someone she believed to be hospital staff under circumstances in which the EMT, a reasonable person would think that she seriously intended to harm someone. For purposes of prelim, I have to prove to a probable cause standard that the defendant communicated this threat, which she definitely did communicate the threat that she had the weapon. She wanted to make the hospital staff pay. She communicated that verbally to the EMT, and then she knew or had reason to know that committing that felony would be dangerous to human life, given that she did not specifically state, I'm going to endanger someone's human life, but obviously that's not the standard. What she would have had reason to know that by driving into the hospital lot area, by making those threats, making the aggressive statements about making those people pay, that indicates that she has knowledge that would be dangerous to human life. And that she intended to intimidate, frighten, or coerce someone of the civilian population, in this case, the hospital staff. She stated to Officer Rotuno as well that she wanted to make them pay, that she had this anger surrounding her alleged prior mistreatment at the hospital. So, additionally, she drove to the hospital with a gun in her car. That was observed by Officer Rotuno. To a probable cause standard, I believe that the testimony presented today proves that. EMT Mr. Toaster also was able to positively identify a defendant as the person who was making those threats to him on August 27th. So, to a probable cause standard, people have proven the elements of making a false terroristic threat, and ask that the court bind over this case as charged.
Michigan Jury Instruction 38.4 under A, it says the defendant communicated that she would commit the felony crime of what again?
In this case, it would be, she didn't specifically allege, but she would be using a firearm to get even with someone or to make them pay. So that would at the very least be a felonious assault, but it could likely, be any range of severity depending on how exactly she intended to use that firearm.
Says here in the jury instructions, an act of terrorism requires a violent felony. So you got to state a felony. It can't be a general thing. You got to tell me what it was.
So during the course conference, they reported that an act of terrorism, so that she would utilize the firearm against individuals.
So the felony you're saying is felonious assault?
Yes.
Okay.
Yes.
Okay, thank you. Defense.
Thank you, Your Honor. Complaint charges that the defendant did threaten to commit an act of terrorism and did communicate that threat to another person. With respect, I disagree with the prosecutor that the officer said the defendant admitted to him that she would quote, make them pay. I don't believe that was his testimony. The threats come through the testimony of Mr. Lozier, who on direct goes down a long list of hyperbole that he later admits what he told the police was true. There were no direct threats about what Tar was going to do with the gun. He felt the threat was implied based on the fact that she said, you don't understand, I have a gun, and the other things. That in and of itself is insufficient to meet the elements of the crime she's charged with. The statute, and the court is alluding to the jury instructions, the statute requires that the person is guilty if they threaten to commit an act of terrorism and communicate that threat to another person. Statute defines an act of terrorism means a willful and deliberate act that is all of the following. An act that would be a violent felony under the laws of this state, whether or not committed in this state. an act that the person knows or has reason to know is dangerous to human life, an act that is intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. It has to be all three of those. I think the difficulty that people have is elucidated quite well by the assistant prosecutor when the court is questioning her about what exactly is the underlying felony, and she's not really even sure. In order to satisfy the actus reus component of this offense, you have to have a willful and deliberate act that is being communicated. And when you have the substance of that testimony being supported only by an EMT who says no direct threats were made and he thought they were implied, you're putting any member of the public, and this defendant in particular, at the whim of his suppositions for a 20-year felony. I know the standard is low, and I understand that the burden is not great for the people at preliminary examination, but they still have to offer competent evidence on each of the elements that are going to have to be proven if the case is found over for trial. And whether the statements were bizarre or concerning or upsetting is not enough to rise to the level of communicating an act of terrorism, threatening to commit an act of terrorism. It just doesn't satisfy the statute. So with all due respect, I object to the bind over. I don't believe that people have satisfied the elements by even a probable cause standard. It's pretty clear that she was having a mental health episode. Both the EMT with his experience and the police officer who petitioned her clearly recognized that. And I understand that the statute doesn't require that the person actually carry it out or even have the ability to carry it out, but there's not a clear indication of what is being threatened. And we learned very early in law school that words alone cannot constitute a crime. Now, there are certain circumstances where, coupled with something else, they may, but in this case, we're here because the EMT thought something was implied. Without more, that's just not enough, Your Honor. So we respectfully object to the motion to bind over and respectfully move that the court dismiss this matter.
The Michigan jury instruction 38.4, making a terrorist threat, is the jury instruction we're relying on today for the purposes of the preliminary examination. Again, as indicated by your attorney, the burden is on the prosecution. So they have to establish that they have sufficient probable cause that a crime was committed, in this case, the crime of false report or threat of terrorism, and then sufficient probable cause to charge you, Megan Tarr, with the crime. This is not a trial. They don't have to prove each element beyond a reasonable doubt. It's a very low burden. It's just more than mere suspicion is the burden of what they need to establish. And it can be established by circumstantial evidence. And today we had testimony of two witnesses, first being a Todd Lozier. He testified that on the date of August 27, 2023, he was present at the area of 1215 East Michigan Avenue, also known as Sparrow Hospital, which is in the city of Lansing, Ingham County, state of Michigan. That makes venue in the court appropriate. He indicated that he was doing some work with his stretcher ambulance when he heard a horn blowing and noticed a vehicle driving rapidly and stopped just in front of his ambulance. He indicated that an individual exited that vehicle. That individual was erratic, rambling and making some chaotic statements. He believed that individual needed some assistance, so he was trying to ascertain how to render assistance, and asking that person, an individual that he later identified in the court today as being the defendant in the court, Megan Tarr. He stated that he couldn't recall what she was wearing. He thought she might be wearing some kind of hospital gown and hospital bottoms, but when his recollection was refreshed, it sounds like she was likely wearing a bra and an adult diaper. He indicated that she was exclaiming some very vulgar statements about wanting to harm all the people at the hospital. He's indicated, and the court specifically asked him a question about what was specifically stated, and the court had to ask that because he did make a statement on his direct, actually on his cross, that the defendant stated that she was going to get everyone back. He did state that there was no specific statement of what she would do, but that she indicated that she would get everyone back, that there was some issue regarding, she appeared to believe she had been mistreated and that she stated, "You don't understand, I have a gun." And so he said that he felt the threat was implied. The defense is arguing that there's been no specific statement of a threat in this particular incident. So if we look at the jury instruction, it says first, to prove this beyond a reasonable doubt, the prosecution would have to prove the defendant communicated that she would commit the felony crime. In this particular case, the prosecution has indicated that the felony would be that of a felonious assault. So use of a weapon in this case to assault individuals at the hospital is what's being alleged. Second, that the defendant knew or had reason to know that committing the felony would be dangerous to human life, meaning that committing the felony would cause a substantial likelihood of death or serious injury, or the felony involved a kidnapping. So in this particular case, the prosecution would allege that the defendant knew or had reason to know that the felony would be dangerous to human life. If you're threatening to get everyone back and stating that you have a gun, that you would implying that you would use it to get everybody at the hospital. Third, that by committing the felony, the defendant would intend to intimidate, frighten, or coerce a civilian population, or influence or affect the conduct of the government or a unit of the government through intimidation or coercion. We had testimony today from Officer Returnal, who indicated he later spoke with the individual identified in court today as Mr. Magentar, and that she indicated that she was having a panic attack, that she confirmed that she did have a firearm and where the firearm was, that she didn't mean to make any threats, but that she was worked up at the time that any statements was made. The argument again of the defense is that there was no specific threats being made. If we look at it again at the jury instruction under the section before we get to what the prosecutor must prove, it says the defendant communicated with, in this particular incident, it would be Mr. Lozier, by speech, writing, gestures, or conduct. In this case, we have a circumstance that involved allegations that Ms. Tarr communicated by speech to Mr. Lozier. Second, that during the course of the communication, the defendant threatened to commit an act of terrorism. It specifically states here in the jury instruction, a threat does not have to be stated in any particular terms, but must express a warning of danger or harm. So she did not have to state, "I'm going to use my gun to shoot you all." It could just say, "I have a gun and I'm going to get you all back." And a reasonable person would infer that you're going to use the gun to get everyone back. So the court is satisfied that there's sufficient probable cause that count one, false report or threat of terrorism, that is satisfied, that will be bound over to the circuit court for a bind over date of May 22nd. You do not need to appear in court on May 22nd unless your attorney makes a motion for you to be rearranged at the circuit court. So without that motion, your next court date will be a pre-trial in the circuit court, okay?
Okay, thank you, Your Honor.
No problem.
Thank you, Your Honor.
Give me just a moment. Our bond was set at 5,000, 10%. That will continue. Any additional matters for today's record?
Nothing for the people.
No, Your Honor, thank you.
You're all set.
Thank you, Your Honor.
You're welcome. The record in the matter of the people of the state of Michigan versus Calvin Thompson, file number is 24-00886.
Karen Robinson, Assistant Public Defender for Mr. Thompson.
Okay. Mr. Thompson, why were you late? Yeah, you said that last time.
Oh, well, a long night with kids, my other kids and stuff. That's all it was. I got 2 other kids. I'm here for.
What's that got to do with you getting to court on time?
Sorry, Your Honor.
This is the second time in a row where you appeared late and you said that you mixed up because you overslept. I have a bench warrant here that I authored to have you remanded. If you're sitting in jail, who's supposed to take care of your kids? So you need to get up and get to court on time. Do you have a phone?
Yes, I do. Ma'am.
What's your phone number?
517-528-2889.
Okay. What kind of phone do you have?
I have a Boost Mobile.
Boost Mobile? That's the Boost Mobile is the who services the phone though, correct? Is that yes?
Yes.
What kind of phone is it?
Motorola.
Okay. Does it have an alarm on it?
Yes.
You know how to set it?
Yes.
Okay, you should do that so you can get to court on time, so that your attorney doesn't have to wait around or come back and forth. So that the witnesses that are here and subpoenaed here don't have to waste their time, and so that the court doesn't have to keep working around your schedule. Okay?
Yes.
All right, this matter is scheduled to proceed to a preliminary examination. It says May 16th at 8:30 before Judge Flores. That's going to continue.
Correct, Your Honor.
I'd like to, Your Honor, yes.
Okay. I'll note that in the file. You need to appear in person on time. Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor. Thank you.
Thank you. You're all set for today. Thank you.